Did the rules on birthright citizenship just change again? On August 6, 2026, President Trump signed 2 new executive orders on this exact topic. And if you saw that headline without any context, I understand exactly why you'd be confused, maybe even a little scared. Was everything we told you wrong? On July 30th, 2026, on this channel, we told you something very specific about birthright citizenship. If you missed that video, here's the short version. The Supreme Court ruled it was fully protected, the ruling was final, and no executive order could undo it. If you're an H-1B, F-1, or green card family expecting a child on American soil, we said that child is a citizen at birth, period. Whether you've been following this story with us from the start, or you're landing on this channel for the first time, stick with me. I'll get everyone caught up in the next few minutes. Stay with me for the next few minutes because the honest answer is more specific and more reassuring than the headlines are making it sound. We're going to walk through exactly what these 2 new orders say, exactly who they apply to, and exactly why the June 30th ruling we told you about is still standing exactly where we left it. Let's start with where things actually stood before this latest announcement, because context matters here. On June 30th, 2026, the Supreme Court ruled 6-3 in a case called Trump versus Barbara. That ruling struck down Trump's original broad executive order from January 2025, the one that tried to deny automatic citizenship to children of undocumented parents and children of parents on temporary visas, including H-1B, F-1, and other categories. The court's majority opinion, written by Chief Justice John Roberts, held that the 14th Amendment's language protects nearly everyone born on U.S. soil, regardless of their parents' immigration status. That ruling is a constitutional decision. It has not been reversed. It cannot be undone by an executive order. That part of what we told you has not changed at all. So what exactly did Trump sign on August 6th? 2 separate orders, and they are narrower, noticeably narrower, than his first attempt. The first order identifies specific, limited categories of people whose children would not be entitled to birthright citizenship. According to White House Deputy Chief of Staff Stephen Miller, these categories include people the administration describes as alien enemies of the United States, members of designated foreign terrorist organizations, and people who act on behalf of foreign governments in certain lobbying or representative capacities. The order frames these as historically recognized exceptions to birthright citizenship, categories the Supreme Court itself acknowledged exist, going back to the same 1898 case, Wong Kim Ark, that established the broad rule in the first place. This is not a return to the January 2025 order. That order tried to exclude undocumented immigrants and temporary visa holders broadly. This one is aimed at a much smaller, specifically defined group tied to foreign hostile or representative activity. The second order is about something different entirely: birth tourism. It directs the Secretary of State and the Secretary of Homeland Security to increase restrictions on visitors who travel to the U.S. specifically to give birth and obtain citizenship for their child. Here's something worth knowing. This isn't actually a brand new legal concept. U.S. law already prohibits obtaining a visa for the primary purpose of giving birth in the country to secure citizenship for a child. What this order does is direct agencies to enforce that existing rule more aggressively, particularly around what officials have called known hotspots for commercial birth tourism operations. Reporting around this order has pointed to countries like China and Russia as the most common arrangements of these commercial arrangements. Now here's the part I want you to really sit with, because this is the actual answer to the question in this video's title. Neither of these 2 orders touches H-1B, F-1, L-1, or green card families. Neither one reopens the question the Supreme Court already answered. If you are living and working in the United States on a valid visa, and your child is born here, the June 30th ruling still applies to you exactly as it did the day it was issued. These new orders are targeted at 2 much narrower situations: a small category of people tied to foreign hostile or representative activity, and commercial birth tourism operations where someone enters the U.S. specifically and only to give birth and leave. If you're finding this update useful, go ahead and subscribe, because immigration policy is clearly not done moving this year, and we're going to keep tracking exactly what changes and what doesn't. Let's clear up the myths already spreading about this because there are already 5 circulating. Myth number 1. This reverses the Supreme Court's June ruling. Reality, it doesn't. A Supreme Court constitutional ruling cannot be reversed by an executive order. These 2 orders operate around the edges the court left open, not through the core of what the court decided. Myth number 2. H-1B and F-1 families are now excluded from birthright citizenship again. Reality, they are not. Both new orders are explicitly narrower than the order the Supreme Court struck down. Temporary visa holders were not named as a target category in either one. Myth number 3. Birth tourism restrictions affect anyone who gives birth in the U.S. while on any kind of visa. Reality. The order is aimed at people whose primary and often documented purpose for entering the country is to give birth and leave, frequently tied to commercial agencies that arrange these trips. It is not aimed at people who are legally living, working, or studying in the U.S. and happen to have a baby during that time. Myth number 4. This will hold up in court without a fight. Reality. Legal experts are already saying both orders are likely to be challenged, since any action touching the 14th Amendment tends to end up in litigation quickly. Trump himself acknowledged the Supreme Court's June ruling was a setback for his broader goal, describing these new actions as adjustments rather than a full reversal attempt. Myth number 5. Nothing needs monitoring going forward because the big legal question is already settled. Reality. The core constitutional question is settled, but enforcement details, legal challenges to these 2 new orders, and how agencies actually implement the birth tourism restrictions are all still developing. Settled and finished are not the same thing here. So what should you actually do if you're an H-1B, F-1, or green card family with a child already born here or expecting one soon? First, nothing changes for you today. No new paperwork, no new filing, nothing to submit because of the August 6th announcement. Second, keep doing exactly what we told you after the June ruling. Hospitals continue issuing standard birth certificates, and the Social Security Administration continues issuing numbers the normal way. Third, if you don't fall into the narrow categories described in the first order, or you're not entering the country specifically and only to give birth, these orders were not written with your situation in mind. Fourth, ignore any social media post claiming there's a new form you need to file because of this update. There isn't one. Fifth, if litigation develops around either order, we'll cover it here. But litigation over these narrower orders doesn't reopen the broad question the Supreme Court already decided in June. Let's talk about the mistakes people are already making with this news, because we're seeing them in real time. Mistake 1. Panicking based on a headline alone, without reading what the order actually covers. Headlines this week have used broad language like limits birthright citizenship, which is technically true, but leaves out how narrow the actual categories are. Mistake 2. Assuming this is a repeat of the January 2025 order. It isn't. That order tried to exclude entire broad categories of temporary visa holders and undocumented parents. This one targets specific, limited groups the courts have historically recognized as exceptions. Mistake 3. Confusing the birth tourism order with anything about people already living in the U.S. on valid status. Someone on an H-1B or F-1 visa who has lived and worked in the country for years is not what this order is describing. Mistake 4. Assuming the June ruling is now in question because a new executive order exists. A ruling and an order are not equal in legal weight. One is constitutional law. The other is a directive that itself has to survive constitutional scrutiny. Mistake 5. Staying silent instead of asking a licensed attorney directly if your family's specific situation feels unclear, especially if there's any factor, visa type, entry purpose, any connection to a foreign government role that makes you unsure which category you fall into. Here's a question worth asking. If the Supreme Court already shut this down once, why come back with a second, narrower attempt instead of walking away entirely? The answer actually tells you a lot about how much weight these new orders really carry. Trump has been vocal about disagreeing with the court's June decision, calling it an unfair outcome, and describing the August 6th orders as adjustments rather than a new attempt at the same broad policy. That word choice matters. An adjustment, by definition, works within the boundaries a court has already drawn. It doesn't try to redraw them. That's consistent with what we're actually seeing in the text of both orders: narrow, defined categories instead of the sweeping language used in the original 2025 order. Legal analysts covering this story have already pointed out that both new orders appear deliberately built around exceptions the Supreme Court itself referenced in its June opinion, rather than around the broader argument the court rejected. That doesn't guarantee either order survives a court challenge. It almost certainly means at least one will be challenged. But it explains why this round looks so different from the first one, and why panic-level headlines don't quite match what's actually written in the orders themselves. Here's the honest summary. On June 30th, 2026, the Supreme Court ruled that birthright citizenship remains fully protected for children born in the U.S., regardless of their parents' visa status, and that ruling still stands untouched today. On August 6th, 2026, President Trump signed two new, narrower executive orders, one targeting a small, specifically defined category tied to foreign hostile or representative activity, and one targeting commercial birth tourism enforcement. Neither order reopens the question for H-1B, F-1, L-1, or green card families. Both are likely to face legal challenges given the constitutional territory they touch. If you're an immigrant family expecting a child on U.S. soil under a valid visa, what we told you on July 30th still holds. Your child is a citizen at birth, and nothing about this latest news changes that for you. This video is for educational purposes only and does not constitute legal advice. Immigration law involves details specific to each family's situation, and legal challenges to these new orders may develop further. Always verify current guidance through official government sources or consult a licensed immigration attorney before making decisions based on your individual case. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming.